Good morning. Happy Thursday. Diddlin Jack posted that the United States Supreme Court in Davis versus United States, 512 USC 453. I'm just saying the citation off the top of my head. I'd have to actually go back and look. He says that stands for the proposition that anytime a suspect who's been detained asks for an attorney, the questioning has to stop, and they have to get an attorney for the detained person. Now, for those of you who aren't aware, Diddlin Jack is Jack Miller, also known as TX Sheepdog 72. And for those who further don't know, I call him Diddling Jack because he actually made a video where he stated, and this is a very close paraphrase, that he doesn't care if you diddle dogs or diddle kids. As long as you're pointing a camera at cops, you're all right in his book. It's a very close paraphrase. He deleted the video, unsurprisingly, from the blowback he received, but he still said it, unironically, as in he meant it. Think about that. Anyway, as one would suspect, Jack is not a legal genius. And Davis versus United States, the quoted Davis or the cited Davis versus United States, maybe he gave a bad citation and he meant a different Davis versus United States. But in the one he gave, a member of the military was suspected of committing a crime. NCIS had him come down to the NCIS station for an interview. They read him his rights. I'm going to make that very clear. They gave him his Miranda warnings, and then he waived them. And then at some point during the interview, he's like, well, maybe I should get a lawyer. And the question was then, well, what happens? Because they gave him his Miranda warnings, they were essentially conceding that it was a custodial interrogation. And if you read the case carefully, you can see that custodial interrogations are what the court is concerned about. And that word custodial is based on the word custody. And what does the word custody mean, Jack? It all goes back to Miranda. Miranda is where that's why they call it the Miranda warning. Miranda is where this started. Now, Miranda was arrested, but there were other cases that the court lumped in with Miranda where people weren't arrested, where they were in what's called custodial interrogation. Now, a custodial interrogation is either where you're arrested and they're interrogating you, or it's circumstances similar to an arrest where they're interrogating you. And by circumstances similar to arrest, I mean circumstances that have the same sort of coercive nature to them. And the court has gone over this multiple times, trying to figure out where a custodial interrogation starts and stops, and it's a question of fact for the lower courts to find out. So let's just start at the beginning, though. You've got a right to counsel. You have a right to an attorney. That stems from two different sources. The first source is from the Sixth Amendment. That's one everybody's aware of. Your right to counsel, it spells it out explicitly in the Sixth Amendment. That attaches, you actually start having that right. You're able to exercise that right as soon as proceedings have been initiated against you. Criminal proceedings initiated against you, boom, you've got a right to counsel. You have a right to an attorney. And, as subsequent cases pointed out, if you can't afford one will be appointed for you. That's your Sixth Amendment right to counsel. But the court understands that you could absolutely F yourself in the a-hole before charges are filed and the case is initiated against you. In that interrogation, you get arrested, you get interrogated, or maybe even you don't get arrested. They just ask you down to the police station, you get interrogated. You could make a false confession. Or you could make a confession that you didn't intend to make, etc. So the court was like, there's also a Fifth Amendment due process right that when you're in custodial interrogation, mostly when you've been arrested, but also when you're basically in circumstances that are close enough to arrest that, the cops might not have said, we're going to arrest you at this point, but you're basically under arrest. then you have a Fifth Amendment due process right to counsel, so you don't F yourself in the a-hole before you get to court. Now, way too many people F themselves in the a-hole before they get to court because they waive their Miranda rights. Don't waive your rights. Anyway, I don't know if I could make this any more clear. Do not talk to the police. Period. End of story. But back to Jack's point. So do you have a right to an attorney if you demand one prior to arrest? And the answer to that is, generally speaking, no. The rule is no. There are exceptions to that rule, and the court is going to look at things like where did the interrogation happen? Did it happen on the side of the road? Did it happen at your front door? Did it happen at a police station? It's much more coercive to be interrogated at a police station. How did you get to the police station? Did they take you there? That's more coercive than if they said, hey, can you come down to the police station and give us an interview? Right? One is more coercive than the other. When you get there, are you allowed to have someone there with you? Or do you have to go into this alone? You know, can my husband be with me? Can my wife be with me? Can my mom be with me? Whoever. It's more coercive if you have to be in there alone. Are you allowed to leave once you get in there? If you're not allowed to leave, that's more coercive. You're much more likely to cough up an answer than if you're allowed to leave. And so all of these, I mean, it's a totality of the circumstances. It's based on a reasonable person, unless you're a minor, in which case it's based on a reasonable minor. But it's not based on, like, if you're drunk, it's not based on a reasonable drunk person. If you are mentally deficient, if you have some mental issues, it's not based on a person similarly situated, a reasonable person with similar mental issues. It's based on, it's generally speaking, except for minors, it's based on just a reasonable person. Would that reasonable person find that situation as coercive as being arrested? That's what you're looking at. And I don't remember the name of the case. It was out of Ohio. The Supreme Court case out of Ohio. It's two names. It's not somebody versus Ohio. It's just two names that are not common names, if I remember correctly. I could be wrong on that. But in this particular Supreme Court case, there was a cop. He saw someone he thought was driving drunk, pulled him over. The guy gets out of the car, has trouble standing up. The cop anticipates he's going to arrest this guy, but he hasn't told the guy yet. And the court said that doesn't matter. So don't worry about that. I guess that's just an aside. But anyway, the cop says, hey, have you been drinking tonight? And the guy's like, yeah, I had a couple beers and I smoked a couple joints. Good old time. Woo. So anyway, as one would suspect, his testimony was used against him in court and he was found guilty. Don't talk to the police. And so he's like, wait a minute, that sucks. Miranda came out. Miranda said, basically, if you're not free to go, right? I wasn't free to go. He pulled me over. I had a right to an attorney. This is essentially Jack's argument. And the court was like, no, this is a short term. It's just a detention. A reasonable person would think that, they're going to get a ticket and they're free to go. It's not coercive like an arrest is. So what should we learn from this? If you're arrested, you have the right to an attorney. That's Miranda. Any interrogation that they give you is going to be a custodial interrogation. If you have not yet been arrested, then that's going to be a question of fact. And it's more than just being detained. It's a lot more than just being detained. Being detained is a factor that the court could use, but it's not a deciding factor that the court is going to say. And in fact, the court rejected that argument. Just because you're detained, that's not enough. That is absolutely not enough. You need more. You need a lot more. So Jack was once again wrong, and still, in Jack's defense, number one, don't talk to the police, and number two, it doesn't hurt to ask for a lawyer. Say, hey, I feel like I'm in a custodial interrogation. I want an attorney. That might help you. It might help you. It might change the attitude of the cops. They may think the way you're thinking, whatever. You can say it. But don't answer questions. At most, say, I'm not answering your question. I'm invoking my fifth, something along those lines. And then if you want to say, I think I need an attorney, then okay. But I wouldn't suggest. I am a big fan of just shutting your pie hole, because they will get you to talk. They get you to talk. That's their job. That's what they're good at. And if you feel like you have to, say, I'm invoking my fifth. If you've been talking to them at any point and then you want to stop talking, definitely invoke your fifth. But before that, if you just don't talk, you'll be fine. Well, at least nothing you say can be used against you at that point. I don't know if you'll necessarily be fine, but they won't be able to use your testimony against you. Anyway, thanks for watching. Have a great day.